Preliminary Declaration of Disclosure. To try to cut down on the cost and frustration of litigation in family court, the California legislature has instituted the duty to exchange declarations of disclosure to parties in a dissolution proceeding. Basically, the legislature has imposed a duty to disclose all financial information upfront in the dissolution process. Petitioner shall serve a preliminary declaration of disclosure, also known by its acronym PDOD, concurrently or within 60 days of filing the petition on the other party, and file a proof of service with the court that the PDOD has been served on the other side. Perjury in the declaration of disclosure may be grounds to set aside a judgment of dissolution, in addition to all other remedies under the law. The preliminary declaration of disclosure shall include copies of the last 2 years of tax returns. The respondent, in turn, shall serve his or her preliminary declaration of disclosure, also known as PDODs, with his or her response, i.e. concurrently with the response, on the petitioner or within 60 days of filing the response. The time for service of the preliminary declaration of disclosure can be extended by agreement of the parties or by order of the court. The preliminary declaration of disclosure has 3 components. First, a cover sheet with disclosure of any business opportunity. Each party must identify on the cover sheet any business opportunity. This means that a party has a duty to disclose any investment, business, or income-producing opportunity that presents itself after the date of separation that is outside the normal course of business. Disclosure must provide adequate time for a spouse to make an informed decision as to whether to participate in the business opportunity or for the family court to resolve any disputes. 2. An income and expense declaration. Each party must complete a current income and expense declaration form with attached current pay stubs or profit loss statement if the declarant is operating a business. 3. A property declaration. Each party must identify all community property and separate property assets and obligations, including percentage of ownership and liability, on a property declaration form. The declaration of disclosure must be executed by the declarant under penalty of perjury on a judicially approved counsel form. The declaration of disclosure packet containing the 3 components mentioned previously is not filed with the court unless court ordered to do so, but proof of service that the packet was served on the other party is filed with the court. Duty to augment. Each party has a duty to make an immediate, full, and accurate update or augmentation to the previous preliminary declaration of disclosure to the extent that there has been a material change to the prior preliminary declaration of disclosure, which means that each party has a duty to augment or supplement or update the preliminary declaration of disclosure if there's been a major change by serving on the other party a supplemental preliminary declaration of disclosure. Final declaration of disclosure. Each party shall serve a final declaration of disclosure 45 days before the first assigned trial date or at the time of agreement for the resolution unless waived by the parties. That means that if the parties enter into a marital settlement agreement, they have to file a final declaration or disclosure or waive it in the marital settlement agreement. In the final declaration of disclosure, the property declaration must reflect all material facts and information concerning the characterization and valuation of assets and obligations, including an updated income and expense declaration with attached current pay stubs. Duty of disclosure ends with agreement or distribution. Once the parties have a valid, enforceable, and binding resolution by agreement, normally through a marital settlement agreement or by court order that divides and distributes the assets or debt, the duty of disclosure ends. In layman's terms, a party to a dissolution proceeding has a duty to voluntarily and accurately disclose all the known assets and debts. A party cannot hide the ball. A party has a duty to voluntarily and accurately declare and disclose all of his or her actual earnings and other post-separation income. Until the assets are divided, a party is like a trustee or a legal administrator of the assets and has to play fair. Examples of breach of fiduciary duty. Here are some examples of breach of fiduciary duty. 1. A party fails to disclose the value of his or her defined contribution pension plan in his or her declaration of disclosure. A party fails to disclose the value of his or her defined benefit pension plan in his or her declaration of disclosure. A party causes unnecessary delays in executing a court-ordered sale of the community property residence, and during the delay, the value of the residence goes drastically down. The party who caused the delay is accountable to the community for the reduction in value of the residence when it actually sells. And last, a party takes out a large cash advance on his or her credit card shortly before separation and gives the money to his or her brother. Remedies. The court has broad discretions to rectify the situation when one spouse breaches his or her fiduciary duty to the other spouse, depending on the severity of the breach. Some of the remedies are as follows. The court can simply set aside a judgment entered on faulty declarations of disclosure. The court can award an asset not disclosed by one spouse on his or her declaration of disclosure entirely to the defrauded spouse. Takeaways. In a dissolution proceeding, i.e. divorce, each spouse is in a fiduciary relationship to the other spouse. This means that the spouse owes a duty of utmost good faith and fair dealing to the other spouse. The parties to a divorce owe a fiduciary duty to the other spouse until the assets and debts are divided by an enforceable agreement or court order. To enforce this fiduciary duty, the California State Legislature has imposed the duty for the parties to exchange declarations of disclosure. A declaration of disclosure includes three components. 1. A cover sheet with a disclosure of all business opportunities. 2. An income and expense declaration which reflects the true income. And 3. A property declaration which discloses all the assets and debts.